Please note that only ACUS members, including government members, public members, senior fellows, liaison representatives, and special counsels, whether or not on the committee, and their designated alternates have full speaking privileges. To avoid background noise, though, I'd ask that you keep your microphone on mute and either use Zoom's handheld raise feature or add a comment in the chat feature if you'd like to speak. I'll then call on you and you can unmute yourself. Please then remute yourself when you are done. I'd also ask that ACUS members and their designated alternates use the webcam to facilitate conversation. With respect to attendees other than ACUS members and alternates, participation requires the unanimous consent of the committee members. Time permitting, I'll consider calling on such attendees at appropriate points and will presume that committee members consent absent their raising an objection. If any such participant would like to speak, please so indicate in the chat feature or by using Zoom's hand raise feature and wait to speak until I call on you. You can then unmute yourself and please remute yourself when you are done speaking. For all participants, please use the chat feature only to indicate that you'd like to speak or for committee members and their alternates to vote when asked. Please do not hold any sidebar discussions or put substantive comments in the chat feature. Only members of the Regulation Committee, including government members and their designated alternates, public members, senior fellows, liaison representatives, and special counsels have a vote. Please do not vote unless you're a member of the committee, and we have a list of committee members in case you are unsure. And I apologize, I am on the phone since I seem to have bandwidth issues today at work, but we will make it work. So thank you, everyone. I guess we can go to where we left off during our last discussion.
Great.
Is that there?
Okay. So I have it up on screen. Can everybody see this? Oh.
Yes.
Great, thank you. All right, so I think we ended. Okay, so we ended at this paragraph. So it's the third paragraph, starting in line 26. We can go through it again if we'd like, or start at the following paragraph, starting at line 34. Erica, I see your hand raised. I don't know how much Helen can see on the phone. So I'll go ahead and call people.
Thank you.
Thanks. So I'm sorry, I'm having trouble seeing it as well, which is on me. The last sentence in that paragraph, that the some agencies also collect information in the course of supervising regulated entities. I'm sure we talked about this last time. I'm just spacing out, but isn't that inconsistent with the footnote 1, where we describe the scope of this, effectively where we describe the scope of the recommendation? Because footnote 1 defines an investigation as steps between becoming aware of a violation and initiating an action. And that sentence seems to be describing information collection that is routine rather than information collection that happens during that window. And if that's right, then I think that sentence doesn't belong there.
Yes. So I will say that this was kind of a confluence of two different suggested edits over the course since the last committee meeting. So Jay Schwartz, who I don't see on here yet, had a comment about identifying that certain financial regulatory institutions conduct investigations on an ongoing basis. At the same time, there was also consideration of defining investigations. And so I take your point that there is obviously some discrepancy between the two, which does need to be edited. So I'll just open up the comment bubble that's here. which has Jay's proposed language in it where he had wanted, indeed, investigative procedures may present challenges for financial regulatory agencies in the performance of ongoing supervision because adopting excessively rigid rules could impede the flow of information and make it more difficult for examiners to identify problems. The Committee on Style proposed this suggested language to include other potential agencies in similar situations.
Can I follow up my comment with a question about that?
Absolutely.
Is he saying then, when he says investigative procedures may present challenges, is he saying that the kinds of ongoing supervision that those agencies conduct should also fall within the scope of this recommendation? Or is he saying that, so, I mean, or is he saying something else? Is he saying that we should be clear that we're not talking about information gathering in the context of this ongoing supervision? Is he saying the opposite?
It's a great question for Jay if he was here.
Yeah.
Yeah. I'm happy to turn it over to Aram if he has any insight from our last meeting.
Sure. Thanks so much, Erica and Kaja. I'm just inferring from what from our exchange with Jay and my exchange back and forth with him. I think it's an administrability point that he is raising because the Board of Governors of the Federal Reserve have such a almost daily back and forth contact with the regulated entities that is distinctly different from the arm's length relationship between most other federal regulatory entities, agencies, and the regulated parties. So that, I think I took that as the core of his point, which is to apply these generalized best practices might formalize the relationship in a way that might be unfavorable to the agency, given that it has such a close, like an unusual close relationship with its regulated parties. There's like constant communication all the time. So obviously he speaks for himself, but that's kind of how I take what he said.
And that would seem to suggest that the thrust of that the inference from that, I think, is that these recommendations should not apply in the context of an agency that has that kind of constant ongoing relationship. In which case this sentence probably should not be here, because this sentence is implying, I think, the opposite.
So I don't think he went that far. I think he just wanted to note that not every aspect of this recommendation could be applied in every way to his particular agency, but then making it general, I feel like it would be difficult for any federal agency to do absolutely everything, at least in the earlier versions of this document that had, sort of sharper edges to it.
Well, and then if that's the case, we have to grapple with the fact that there is an inconsistency between this sentence and the definition of investigation at the front, right? Because that definition says that this recommendation is about the steps that an agency takes between deciding that there's a potential violation and moving forward, taking action against it. And if the kinds of interactions that he is describing are also covered by this, then that definition isn't broad enough.
So if I could respond in two respects. First, it's my personal view that the footnote isn't needed because ACUS only recommends, first of all. And second, with regard to the broader definition, I would say the definition is somewhat broader than what you described it. Essentially, if agencies are engaging in non-routine information gathering exchanges, that's typically where this sort of comes in. So as opposed to, because what we don't want this is to be, when tax day is coming up, you file a tax return, we wouldn't want every single person who files a tax return, to then all of a sudden trigger whatever the back process functions are with the IRS for data collection and auditing and things like that. But certainly in the context of then IRS doing a follow-up with any individual person, then it certainly does trigger.
Okay.
So
So
hopefully
is he,
that's helpful.
yeah, I guess just the last question then, is he not describing the routine practice of those agencies?
I think we hadn't quite gotten to that part of,
Okay.
we didn't spend
Okay.
a ton of time talking about it, but, and again, without trying to step into his shoes, he might be, I would imagine he might respond favorably, but I don't want to overclaim.
Okay.
Jay is himself and only he can speak for himself.
All right.
I mean,
Yeah,
Erica,
right.
if I could just jump in real quick. I mean, would it be consistent with your understanding of the definition, Aram, your understanding of what Jay was getting at, to say something at line 30 like some agencies collect informal information or review information collected through routine in information collections before determining whether to initiate a formal investigation?
Yeah, I think so. I think an acknowledgement that varying agencies can have varying definitions of what routine is. So given that there are fewer depository institutions, and that the Board of Governors has existed for a long time and it's bifurcated into different geographic areas, that's just a naturally very different relationship with, let's say, EPA and potential, lead paint rule violators. Because again, we're trying to come up with a trans-substantive general recommendation for a whole variety of things that happen in the federal government in this domain.
Well, if nobody else is worried about the definition in footnote 1 being somewhat contradicted by this, then I will recede.
Jeremy, can you just repeat the information or the wording that you had used?
How about just combine the two? Some agencies collect informal information or review information collected in the course of supervising regulated entities before determining whether to initiate a formal investigation.
That works.
Okay. And then does the committee want us to keep footnote 7, which is basically just a C, for example, previous ACUS recommendation on adjudication practices and procedures of the federal bank regulatory agencies? We can get rid of it. Or keep.
I would recommend getting rid of it, but that's
Okay.
That's me.
Okay, so I will remove the split and go back down. All right. Is there any other comments or proposed changes for this paragraph? Okay, we'll just go down to the next one, which starts on line 35. There is also a comment here from Kayla. If you want to unmute and talk about any of this or whether or not it's still something that you would want to talk about.
Yeah, so getting distracted by my video camera. I thought it would be beneficial to have a definition that it says what a compulsory process does rather than just giving examples of compulsory processes. So I didn't draft this definition, but I like having it in there.
All right, I'll just give everybody just a moment to read through it.
I guess the one change I might suggest is we have in here compel a party. Is it clear what a party is? Might it be better to change that to person, including legal persons?
What line?
That would be line 40.
Oh, okay, I see, thank you. We could say person. That works. Erica, I see your hand up too.
Yeah, I wanted to suggest maybe we don't need the 4 violations of the law to produce testimony, records, information, or things, or to submit to a search. Maybe just stop with that rather. The 4 violations of the law is very precise, and you know, if the idea is there's already suspicion that there is a violation of the law, I suppose that's what the search is for. But the search maybe to assess whether there has been one. So I guess I would recommend just stopping with submit to a search. It's not obvious to me we really need the rest of that. That would be my suggestion.
Okay. Aram?
I agree with Erica. I just wanted to also note, opening that door, just giving examples of what that looks like without that limiter, which again, I agree with the edit, would be sometimes an agency wants to investigate whether a policy is functioning correctly. So it uses its investigative authority to essentially audit regulated entities. It might want to be doing analysis on what its own jurisdiction ought to be. It might just want to do a randomized audit, with generalized authority. All of those are things that I think we would want this recommendation to cover. I'm just giving examples of what that would look like for non-suspected violations of law.
Any other comments on this paragraph? Okay, so we will move on to the next one. There's some verbiage change here from Jeff Lubbers, who couldn't join today. But I also just want to remind everyone that he's not on the committee, although he is a special counsel. Any concerns, edits on this? Are we okay with his proposed language? Kayla, I got a thumbs up from you. All right, well, hearing no objections, I will just presumably adopt that. We'll just give it a thumbs up there. Okay. All right, any other comments, edits on this paragraph? All right, let's move on to the next one, which starts at line 54. This one just summarizes what the recommendation talks about. Again, proposed edit from Jeff Lubbers was to add numbers in front of the listed items. And then Committee on Style added this sentence at the request of the committee to recognize that not all of these recommendations may be appropriate for certain agencies or certain investigations. Any objections to these edits? All right. So we've now gone through the preamble. There were some edits made above as well between our last meeting and this one. I'm happy to go back up to the preamble or continue down to review the recommendations. Does anybody have a preference for how they'd like to proceed on that? Okay, I'm gonna go down to the recommendations. Let's go through the recommendations one more time, and then we'll go back up to the preamble and review what we just did. All right. So, okay, back to the recommendations. There we go. So recommendation number 1, agencies should include in their enforcement manuals information about agency investigative procedures. That should obviously be including the use of electronic submissions and artificial intelligence consistent with recommendation 22-5 regulatory enforcement manuals and recommendation 2024-5 using algorithmic tools in regulatory enforcement respectively. Any concerns, issues, edits on this one? All right, seeing none, I'm going to move on to the second one. I will note Jeff Lubbers had a proposed edit to moving this one to the next heading because it does not necessarily talk about disclosure and transparency. So I will just read it and then would like the committee's opinion on that. So agencies should determine before taking investigative acts whether and to what extent they may be required by statute or otherwise to coordinate with another agency. Agencies should disclose in their enforcement manuals the circumstances in which and the extent to which they must coordinate with another agency when conducting an investigation. Erica?
It seems to me that it actually belongs here, given the point of it, I think, is the second sentence. The first sentence is establishing the obligation to figure it out first.
Yeah.
So I'd leave it here.
Any objections to leaving it in this section? All right, seeing none, I'll just delete that and we will leave it here. Okay, jumping to the next section, initiating investigations. Recommendation 3, agencies should establish procedures within their enforcement manuals that clearly explain whether enforcement personnel may initiate investigations independently or whether they must first gain approval from a supervisor or other agency official. Any objections to this recommendation? 'All Yes.
Jennifer Dickey. We're looking at the footnote 13.
Oh, no, sorry, recommendation 3.
Oh. No.
Thank you, Jen. Okay, well, seeing no objections to that, we'll move on to recommendation number 4. Agencies should provide enforcement personnel with clear criteria to determine whether to proceed with an investigation. Any objections or edits to that one? All right. Next section, investigative methods. So number 5 is a big one, so we'll go through that one as well. If an agency seeks information, either formally or informally, from the subject of an initiated investigation, the agency should communicate to the subject, A, the scope and general nature of the investigation, B, the potential violations of statutes or regulations being investigated, C, the date by which the subject must submit the information or otherwise respond to the request, including procedures for requesting an extension of time. D, whether any challenge or appeal process exists regarding the request. E, whether the information is being sought through a compulsory or voluntary process. And F, whether refusal to provide the information sought may initiate a compulsory process. So I'll give everybody a moment to review that and then ask if there are any objections or edits. All right, seeing no comments, we'll move on to the next one, number 6. Agencies should develop clear procedures and include such procedures in enforcement manuals for how they facilitate the exchange of information and evidence between the subject of an investigation and the agency. Any objections or edits? All right, hearing none, we'll move on to number 7. This one doesn't. Okay. So this one has an edit suggested by the Committee on Style to remove this qualifier because it was added to the definition in the preamble. So I'll just read it as edited. When an agency engages in a compulsory process, it should clearly specify the basis in law for such compulsory process and whether any conduct or forbearance of conduct by the subject gave rise to such compulsory process. Agencies should provide appropriate time for the subjects of investigations to respond to compulsory processes before seeking judicial intervention. So I'll give everybody a moment to review that and then ask if there are any objections or edits. All right, seeing none. Gonna move on to number 8, which has a proposed edit from Erica Litzen. So Erica, I'm just gonna turn to you to discuss this.
Okay, so my only concern was I thought it was a little awkward to say agencies should notify the agency head. So I just made it clear that the agency officers who initiate compulsory processes should notify the agency head of the use. If it's viewed as important to clarify that we're talking about agency officers to whom the authority to engage in the process has been delegated, we could add that, but it wasn't obvious to me that needed to be added. But if you want to, yeah, to whom the authority to engage, it was the engage in compulsory processes. So to whom the agency officers, to whom the authority to engage in compulsory processes has been delegated, and who initiate those processes should notify the agency head. Yeah. If it's viewed as important to add that qualifier. But the point I was trying to make clear, it was to fix the awkwardness of saying the agency should notify the agency head.
Yeah, completely agree. Aram?
Thanks. My only observation is using the word officers could cause some confusion with like Article 2, Section 2, Clause 2 officers.
I meant to say officials.
I would even say like personnel or employees, just simple word switch. I think that's what you're getting at. So
actually, I was just trying to use the wording of the prior version. So
Yes.
I agree. It's like something I came up only because I was looking at a change.
gotcha.
We did use officials previously, so I'm inclined to just stay with that.
Officials is fine. Just the word officer just sort of carries like an ambiguity. Yeah.
For sure.
Okay. Are there any other comments, edits, objections to this as currently written with the additional qualifier to whom the authority to engage in compulsory processes has been delegated? Right, seeing none, that's the language we're going with. Okay. Recommendation 9. As applicable, agencies should establish processes for administrative review of decisions regarding compulsory processes. Such processes should allow the subject of the compulsory process to seek review on an interlocutory basis, or at least allow for review before the agency seeks judicial enforcement. All right, any objections or edits to this?
Sorry, this is Helen. I can't.
That's
raise
okay.
my
Hi,
hand
Helen.
on the- I have one question about on this recommendation. Are we considering these compulsory processes being administrative compulsory processes? Because I know some agencies, for their subpoenas or their warrants, they have to go to the federal courts to have them issued. And some agencies, based off of their statutes, might be able to have subpoena power of their own. So depending on what we're trying to capture here, I don't know, we might have edits. Because if an agency already has to go to a court to be able to get their warrant or their subpoena, then as written, that's kind of problematic. But if they can do it administratively first, and then then also go to a court if someone is like not following their subpoena, then that I can see where this comes into play. So that's why I have that question.
Yeah, absolutely. I think Aram, you probably, I know that you had talked about this as well.
Yeah, sure. So that's a true statement, Helen. Some agencies only have the ability to engage in this function through the Article 3 process or Article 1, depending. So I'm just thinking on my feet here. So as to the first sentence, I think we would want agencies, regardless of the, application mechanism, even if it's Article 3, to comply with the first sentence. Just like, have you considered whether you can satisfy the standard? So that one I'm not concerned with. The second sentence, I think you're right, Ellen. Such consideration should include. So I think if there's, I cannot immediately think of the way to parse it, but it's the second sentence for which the bifurcation would make sense.
I mean, would you cabinet to say like when compulsory processes are issued through a court or not issued through a court? Jeremy?
Would you say something like when agencies issue an order through a compulsory process? Because then it's actually tethered to some agency taking some order within its authority. So if an agency lacks subpoena authority.
That's right. I appreciate your asymmetric ACUS brief, drafting knowledge. Yeah, that sounds right.
Great.
Helen, does that make sense to you as well?
Yeah, no, thank you. It's an elegant solution.
Okay. Any other edits, concerns with this recommendation? All right, seeing none. We're going to go to the next section, determining the appropriate course of action following an investigation. There is a comment here as well from Jeff Lubbers. Let me just read the recommendation first before we get to that. So the recommendation reads, agencies should direct enforcement personnel and include in enforcement manuals how they should consider evidence relating to investigations before recommending or conducting enforcement or other administrative actions. Such considerations should include the appropriate standard of proof an agency must demonstrate in administrative proceedings, whether that standard differs from the preponderance of the evidence standard used by federal district courts in civil cases, and where the burden of proof rests in particular cases. Just going to let everybody kind of sit with that for a second. Okay, and then Jeff Leber's comment was, according to Stedman v. SEC, the standard of proof in APA formal adjudications is also normally the preponderance of the evidence test. So I'm not sure what this recommendation is adding. Maybe it should recommend that the manual flesh out the meaning of that test. Or
So I appreciate Jeff's comments. So at least the way I read Stedman, like, remember this off the top of my head right now, it's normally, not always. And we're doing an always recommendation. So I think several agencies would just naturally arrive at, certainly the SEC would, oh, there's a preponderance test, and then there's nuance to build out. So I would suggest that the text as drafted remains stable, because what we're not doing is prescribing a particular test, but just having the agencies go through the work of determining it for themselves with their organic statute, just sort of like a NEPA deep think process. We're not so prescriptive as to run afoul of Stedman, and Stedman doesn't cover the entire gamut.
yeah, I think that that's a valid point. I saw a couple of people unmute or turn their cameras on, so I just wanted to check if there were any additional edits or comments on this. Okay, so Kayla, sorry.
Thanks. My comment would just be, I think fleshing out the meaning of a legal standard is something that I would normally consider to rest with the attorneys and not necessarily the enforcement staff. So that is a consideration against describing more fully what that standard is in our recommendation.
Would you then suggest maybe agency should direct the appropriate personnel as opposed to enforcement personnel?
I would agree with that. Kayla's right. So some agencies have like enforcement and then the attorneys. Other agencies have like an entire bureau where the attorneys are integrated. They're part of the enforcement or they're leading the enforcement, for example. That's a good observation, just to make it the right personnel.
Yes, I agree with that. And I guess I do not think we need to add more text on the preponderance standard. That's just my thought.
Great. Okay, so we are going to reject Jeff's comment. And keep this as is with the change from enforcement to the appropriate. And then Kayla, did you still have your hand raised or are you good?
I did not. I will lower it.
Okay, thanks. Okay, any other comments, edits, suggestions on recommendation 10? All right, great. Seeing none, I'm going to move on to 11. So this recommendation says agencies should provide and include in enforcement manuals the relevant factors for enforcement decision makers to consider, including any supporting documentation such as justification memoranda, when determining whether an investigation should be recommended for enforcement action or termination, or to offer or enter into a settlement with the subject of the investigation. Any objections or edits to this recommendation?
Kaja, can I ask you quickly? So supporting documentation is not a relevant factor. What is that intended to modify?
Turn that over to Adam.
Yeah, so I think, Jeremy, when we were drafting this, I was looking predominantly at CFPB practice, which was a big part of the underlying report. And there's a couple of different investigative methods where whoever the enforcement personnel or investigation personnel, they have to issue like a memorandum in support of opening an investigative action. And so I wanted to encompass that in number 11. But if it doesn't seem like that's doing any heavy lifting, I don't think that it would change substantively if we remove.
It's not a substantive question, just that documentation is not a factor to consider. Do you mean to say something like including in any supporting documentation?
I think predominantly I was looking at if there was supporting documentation that was required by an agency.
Okay. So if there's like 5 factors to consider and you're writing a justification memo, detail your findings in the justification memo. Okay, so including in. Thank you.
Sorry, would it be in or including those in?
I think we know the meaning at this point. We can probably committee on style the rest of it. But the idea is that if you're preparing a memo, that's where you would detail how you considered specific factors, if I'm understanding correctly.
Yes.
Great.
Okay. Any other edits, objections to this recommendation? Okay, seeing none, let's move on to recommendation 12. So we do have just one comment on there from Jeff Lubbers again. I will read the whole recommendation and then address his comment. So 12, agencies should provide notice to the subjects of investigations before an enforcement action is initiated unless there are compelling reasons not to do so. That notice should provide, A, that the agency has found substantial grounds for taking enforcement action against the alleged misconduct of the recipient. B, a detailed factual description of the alleged violations. C, the legal basis for the enforcement action. D, an invitation to respond to the evidence against the recipient if applicable. And E, the forum and venue in which the enforcement action will take place. Jeff's comment reads, did the committee consider the SEC Wells notice? Okay, sorry. The SEC Wells notice, the process by which the SEC Enforcement Division notifies potential targets of enforcement actions of an opportunity to submit additional evidence and argument to dissuade the commissioners from following the Enforcement Division's recommendations. He said if you wanted to cover it, you could add an additional point to the list, whether the subject of an investigation would be afforded an opportunity to submit additional evidence or argument before a final enforcement decision is made. Aram?
The answer is yes, and also yes. I think if the committee felt comfortable adding that final bullet would make sense. In the report, I covered pretty deeply Wells notices and smiled upon them as a paragon of good procedure.
Would this kind of be added to D, or do you think it should be a separate recommendation?
I would recommend a separate recommendation,
Yeah.
and this my first observation of seeing how the conference works, so that when we get to plenary, there's line items that are very specific.
So whether the subject of an investigation would be afforded an opportunity to submit additional evidence or argument for a final enforcement decision is made. Okay. Any objections to that addition? Any concerns or additional edits? Okay. Seeing none, I will move on to recommendation 13. Which reads, when agencies terminate investigations, they should notify the subject that they have done so. Again, there is a comment from non-committee member, special counsel Jeff Lubbers. Does the committee want to say anything about the problem of agencies leaving open but not closed investigations hanging indefinitely? I recognize that in some cases, the agency may find and want to communicate to the target that no enforcement action is warranted at this time, but it reserves the right to keep the investigation open. I believe we did talk about this at the first meeting, and I believe, Helen, it was one of your concerns. Correct me if I'm wrong, but I'll just offer any members to opine on that. Aram?
So this is the question on the problem of agencies opening but not closing investigations.
Yeah.
Yeah, I think it's a clear and present problem with differing rates of participation in that problem from agency to agency. I don't know, in terms of the ACUS norms, I don't know if it makes sense to make that like a declaration of here's the problem, here's what we're solving, because we don't do that for a lot of other things here. But yes, it is a true statement.
And this is Helen. There's a lot of legitimate reasons why agencies don't do this, like why we don't send a letter back saying, you know, we've closed this investigation. One, just because we close it, you know, someone might try to rely on that later and saying, well, wait a minute, now that means like I have a get out of jail card, you know, like you can't come after me later.
Right.
Someone else might try to say, well, but you didn't go after the same person for that, and now you wrote this letter closing it, and so like a no action thing. So you didn't go after them for that, therefore, you know, we want some sort of kind of no action assurance. So, and you could be terminating investigation for a lot of reasons that might, you know, like someone might have actually, you know, done something and you might be terminating it for a lot of reasons. And so, and I just, yeah, that's, so there's a lot of reasons why we don't do no action letters. And there might be a lot of reasons why it's still sitting out there. So that's why even like we should notify him that we've terminated the investigation. I'm like, even how do you define at the end of the day what is a terminated investigation? That's why this one still gives me pause a little bit. I'm just, you know, like what is it we're trying to cure here, and what are the potential other problems we might be creating by you know, handcuffing agencies too. So
Yeah, sure. So I've worked in agencies, a variety of different ones, either on a direct or detailed or representing such agencies that engage in my government days, that did all of the above. I have not observed a circumstance where an agency's just garden variety closure of the investigation, as in it's not investigating anymore, can't be communicated by a letter. In terms of like the res judicata effect, varying agencies have different ways of reacting to that one way or another. So there's always terminology text that provides sort of a savings clause. What this means, whether it's like a no action at the one maximum, at the other end of the maximum, agency reserves all rights to continue. Even further than the other end of the spectrum would be sometimes wage an hour will close out an investigation, but then the way that the regulations work is if they close the investigation saying we found something wrong, but we're not going to enforce upon it, and then the next time they enforce, that can be an aggravating factor for purposes of what the penalty is. So, but at the end of the day, I think in many circumstances, but not all, that sentence, you know, line 135 is okay, because agencies can and do utilize all kinds of language in terms of the consequences of what that closure is. I do think you know, public policy strongly supports a target of under investigation getting some notice that it's not just permanently under investigation.
Jen?
Yeah, so I work at the chamber, and I know I've heard sort of complaints from our members about, you know, an investigation just being like potentially open for years and years, where there's like no sense that like any, you know, action is happening. And in fact, probably the agency has walked away, but it's like a thing that continues to sort of dog them and have knock-on implications for all of their disclosure obligations, some of their like licensing applications and the like. So I think as long as it's phrased as like should, that I think does leave room for, you know, extraordinary circumstances. But I think in the main, this is a positive recommendation for sort of good government. Just that if they have truly stopped focusing on you know, have truly terminated the investigation, they're not pursuing anymore, it would be helpful for the regulated public to, or the regulated person to know that.
Kayla?
So I noticed that for recommendation 12 in line 119, we have the sort of caveat, unless there are compelling reasons not to do so. I wonder if that belongs at the end of recommendation 13 also, recognizing Jennifer's points and others' points, but just kind of leaving the door open if there's really a strong reason not to give this notification.
I guess I'll turn it, Jen, would that address your concerns?
I mean, I would probably be fine without adding that, but I also don't think it would be like problematic to add it, because I think compelling is a high burden, and I think we're still saying generally they should notify, which I think is a positive development. So if that like makes some of the agency folks more comfortable, I'd be comfortable with that.
Aram, I saw your hand up as well.
Yeah, just to echo Jennifer's views on that. There could be certain circumstances where a national security agency, like they might knock once, but then they just want to confirm that they might not have a reason to knock again or to communicate. But I do agree, if the standard is that there's a compelling sort of individualized or policy reason, that's an affirmative decision as opposed to just sort of letting things just sort of drift, in the ether. That's a good, that would be okay, I suppose.
Helen, did you want to add anything?
No, I'm liking where this is good, because I like having the compelling reasons, and then maybe having the definitive language that it's actually been terminated, because sometimes maybe one of the reasons we're not giving a notice, or it's not my agency specifically, but an agency might be, maybe they've decided not to keep moving on it because we're not going the administrative route, because it might be going a criminal route instead. And so if you do something that makes it look like there's a no assurance letter, then someone's going to waive that and say, but wait a minute, you just said we did anything bad, but now someone's coming after me for a criminal violation of the same thing. And so like I can see the considerations where, there are times where an agency is not going to want to be putting something out in writing because it can be going against other compelling interests that are in the government's interests there too. So I think, having the disclaimer language on there helps.
Any other comments or edits on this? Any objections to adding the clause at the end? Okay, so we will keep it as is with the additional clause at the end. Okay, last section for the recommendations, negotiation and settlement procedures. 14, agencies should develop procedures and include such procedures in enforcement manuals for entering into negotiations with the subjects of investigations. Agencies should determine the extent to which their rules permit negotiating with subjects of investigations. Considerations to determine whether and to what extent agencies should negotiate with the subject of an investigation should include, A, relevant agency policies or past practices, B, the nature of the alleged violation, C, whether the alleged violation is the first alleged violation by the subject, D, whether the subject would be more likely because of such negotiation to come into compliance with the agency's interpretation of the regulation or statute that was allegedly violated. And and then E, whether a form of expedited settlement, which reduces penalties and minimizes transaction costs in lieu of the traditional administrative enforcement process would be more efficient for agency time and resources. And F, whether the public interest would weigh in favor of negotiating a settlement. We did have debate on 14D quite a bit at one of the previous meetings. And the committee deferred to Committee on Style for implementing language. So D is proposed language from Committee on Style based on previous discussions. So I'll just let everybody review that, sit with it for a little bit, and then ask if there are any objections, edits, concerns. All right, seeing no hands raised, before we move on, I just want to make sure everyone's okay with the language that was proposed in 14D. All right, we will go ahead and move on to our last recommendation, 15. Agencies should provide and include in their enforcement manuals the relevant factors for enforcement personnel to consider when determining whether settlement is appropriate, and clearly state, who at the agency can propose, discuss, or enter into settlement agreements. Any proposed edits, objections, concerns? Okay, we've just gone through all of the recommendations again. I will just offer up one last time if anyone has any edits or objections on it. If not, then we'll go back to the preamble. Aram?
Sorry, if we can, so this is great. If we can scroll up to the footnote, I think it's like 13.
It is
Couple-
13 at the end of the preamble, yes. I also mentally thought about that. So yeah, let's go up to that and then we'll go back to the beginning of the preamble. Okay. And then I'll just ask too, is there any other edits or objections to the recommendation portion? Okay. All right. So back to this last paragraph of the preamble. One of the Committee on Style proposed additions at the request of the committee was to say that, you know, these agencies should account for these differences when implementing the best practices below. And that there isn't going to be like a one-size-fits-all type of opportunity. Footnote 13. Again, I think this was to Jay Schwartz' concern. Unfortunately, he isn't on here. But footnote 13 says, for example, administrative investigative procedures may present challenges for financial regulatory agencies in the performance of ongoing supervision because adopting excessively rigid rules could impede the flow of information and make it more difficult for examiners to identify problems. So this is for the most part, I think Jay's specifically proposed language that he wanted above. Yes, so that is Jay's very particular comment in that footnote. So were there any questions or concerns about that addition?
This is Jen Dickey.
Yeah.
I didn't really, I guess I had some concerns about adding it. I feel like it's very specific to the supervision process with certain agencies in a way that felt sort of at odds with how we normally do these things. And like when I feel like we don't necessarily need to like weigh in on whether this would present challenges in the performance of supervision. When we can just say agencies should account for these differences when implementing the best practices below. It just felt like a very specific call out that is not something I normally think of in our recommendations. And also like it kind of suggests that we think these are excessively rigid rules in some way. And I don't think that they're rigid rules. I think that they're like guidelines for disclosure and transparency. So I would propose cutting footnote 13. Or I would oppose adding it, whatever the proper procedure is.
Sure. Does anyone have an objection to cutting that footnote 13? Okay, so I'm going to add that as a proposed edit that we delete footnote 13 and then Jay can always raise it at the plenary. Okay, so I'm going to scroll back up to the beginning of the preamble. We'll just go through it one more time and then maybe we'll be done. We shall see. Okay. So let's just break this up into sentences, I guess, may be the easiest way. So the first sentence, just many federal agencies are responsible for detecting, investigating, and prosecuting potential violations of the statutes and regulations they administer. I will say footnote 1 was added to include a definition at the request of the committee. So Committee on Style added this suggested language to define the scope of investigations for this project and recognize that there are instances where recommendations may be unsuitable and that agencies may have varying obligations based on statute. So I will just read the footnote since it's new language. For purposes of this recommendation, an investigation means the steps that an agency takes between becoming aware of a potential violation of a statute or regulation and the initiation of an action in an administrative or judicial tribunal, including targeted audits or non-routine inspections. This recommendation does not address investigations conducted for general fact-finding or policy-making purposes, routine inspections, accident or incident investigations when the agency lacks authority to initiate an enforcement action, or criminal investigations. Does anybody have any edits or objections? Jen, Dickey, I saw you unmuted yourself.
Is that accurate? Is that what we mean? I thought, I think I missed the second meeting, but the first meeting, there was a lot of talk about like OSHA reporting, and like stuff like that on this, and where it's like routine reports. And so do we really think that none of that is covered? I guess this seemed narrower to me than what I understood people to be talking about in the first meeting.
I will offer, Arm, I'll go to you in a second, but I'll also just offer that, you know, any of our other government members who were on here, I think probably raised this issue as well. So feel free to jump in. But Arm, go ahead.
I agree with what Jennifer said. I think, at least if you look at the report, and then also if you look at just even earlier today, like my exchange with Professor Litzen, it's a little broader than that. But certainly we wouldn't want it to include routine things like my best example is we wouldn't want to define the process of submitting a tax return to the IRS and then the IRS looking at that as an investigation without more. So, but I do think the definition is more expansive than this because just like what I was talking about with Professor Litzen, there could be investigative processes for an agency determining its own jurisdiction, agency deciding to do non-routine spot checks, at the various time or allocation of enforcement resources to double check or inspect more outside of the routine. And that I think we would want to trigger these common sense processes.
Any other thoughts?
So sorry. So what is the proposal? Because like I thought we were thinking again like the language about aware of a potential violation of a statute or regulation was like, I guess when we were having that meeting, it seemed like we were thinking this would cover some activities that are before they're aware of the potential violation necessarily. Like they're just deciding, they're investigating. They're kind of like, I don't know. There's smoke but no fire. They're not like really, I don't know. Maybe it gets it by saying aware of a potential violation, but like I guess I had the impression it was broader.
At least the way I did the report and the research, it is, and I think you're right. But then what does the committee want to do with the definition?
Kayla?
In my opinion, the subject of best practices for routine investigations is so broad, especially for agencies that do a lot of these, that you could, do another whole report on it. And I guess in my mind, that weighs in favor of excluding them from this set of recommendations.
I wonder if it should be more framed as like that an agency takes with respect to, a particular individual before the initiation of an action in administrative or something about that, like where it's not so much tied to between becoming aware of a potential violation. And then maybe I would probably leave in, it doesn't address investigations conducted for general fact finding or policy making purposes, maybe. Or yeah, the second sentence strikes me as largely okay. I think it's the first sentence. Maybe you could just cut the first sentence and just go to the second sentence.
Yes.
Also,
I was just going to add that I believe it was Peter Strauss that felt very strongly about including a definition. He's not on this call. So yeah, I mean, at this point, if the committee members that are on this call come to a consensus about what to do, like certainly we can look at that. Yes. I mean, are there issues with cutting the first sentence? Does anybody have an objection to cutting the first sentence entirely?
No objection from me.
Okay. All right, then I will just add that as an edit, which we'll accept. All right. Any other comments on the first sentence and footnote 1? Great. Thank you, everybody. Next paragraph is pretty large, so I'll just give everybody time to read that. I already went over that. And then there's a proposed edit in this section from the Committee on Style to just kind of remove some duplicative language with the word investigate, process, and investigative proceeding. And I'm happy to read the sentence out loud if that is helpful for anyone. Any edits, objections, concerns with this paragraph? Or with this sentence, I should say? All right, we will move on to the next sentence. So this one just talks about previous ACUS projects related to this space. And then I'll just highlight in the footnote, it references the following previous recommendations: regulatory enforcement manuals, public availability of settlement agreements and agency enforcement proceedings, agency use of third-party programs to assess regulatory compliance, using algorithmic tools in regulatory enforcement, and then a C also to proactive disclosure of agency legal materials. And then a proposed addition from Jeff Lubbers was to include recommendation 79-3, which is agency assessment and mitigation of civil money penalties. So any objections or edits to that paragraph or the footnote? All right, seeing none, we'll move on to the last sentence in this paragraph, which is split over 2 pages. All right, seeing no objections, I'll move on to the next paragraph. So we'll just go sentence by sentence. So the first sentence, and I don't know if it's helpful for me to read it out loud for people, please let me know. If not, I'll just let you all read it yourselves. All right, we'll move on to the next one. And the 2 footnotes for this one cite obviously to the APA section 555 and see also to a previous ACUS statement on right to consult with counsel and agency investigations. All right, no objections or edits. All right, last sentence of this paragraph talks about enforcement manuals. All right, seeing no hands, we'll move on. Lines 26 to 28. Outlining investigative procedures. And this is the paragraph that we started with. So the following 2 sentences have our edits from earlier in this meeting. All right, seeing no hands, we'll continue to move on just to bring everything to a close. We'll just do one more review of what we did earlier on this preamble, just to make sure everything's copacetic. Okay, we'll go through the paragraph between lines 35 and 43, both with committee on style edits and edits from earlier this meeting. All right, seeing no hands. Go to this last paragraph, 44 through 53. All right, seeing no hands again. We'll go through the last paragraph, which we already reviewed. I'll just reiterate that we got rid of 13, and we're adding the numbers here for the list. All right, any further objections or edits to the document? If there aren't, I will turn it over to Helen. If you would like to call a vote.
Thank you, Kaja. Thank you so much for helping with this meeting today, too.
I know, I'm
everyone's
so
gonna-
sorry. I feel so bad.
I'm sorry about the IT glitches today, too, but I got the email saying the IT glitches, so it's not just me. So thank you, everyone, and thank you for the excellent participation today and your wonderful edits. So we shall call a vote to see if we have, for everyone who we get your agreement to move with your edits and to move forward with the recommendation. So everyone that, so should we just go with the ayes? For anyone who can vote, put your hands up. Unless you can't, like me. Thank you, Erica. We'll give everybody a moment to either you can get off camera or you can raise your hand. Either one is fine. I will give Taja a moment to count.
Yes, I'll just say, Kayla and Courtney, you are also on this committee. So feel free to vote. If you're
This is
able.
Kayla. I'm going to abstain from voting.
Okay. Okay, well, Helen, are you for this recommendation?
Yeah.
Okay, great. Okay, small committee member group here today, but we appreciate everybody's help and assistance and input.
And then, if anyone is opposed to it, do we want to see if we have any? I don't see any hands. All right. Well, thank you, everybody.
Thank you.
We
So,
look forward-
I was just gonna say, we'll clean it up and then we'll circulate the final version to everybody on the committee, and we'll look forward to seeing you all virtually or in person at the plenary session on June 12th.
Thank you so much.
All right, take care, everybody. Thank you.
Thank you.